We ready? Welcome. Good afternoon. Welcome to the Banking and Consumer Affairs Subcommittee. We'll get things started here with roll call. Everybody punched in, ready to go. Madam Clerk, please open up the roll call. Please take the roll.
Mr. Chairman, you have 5 members present. You have a quorum.
Thank you, Madam Clerk. And as always, the folks to the left and to the right and in the front, they're the ones that make this thing happen, and very appreciative. But we'll jump right in here. Get ready to get started here. We're ready for House Bill 2542 by Representative Renault. Representative Renault, please tell us about your bill.
Thank you, Mr. Chairman and committee. This is just a cleanup bill to the Tennessee's unemployment insurance statute that removes some outdated language and conflicting language defining what qualifies as suitable work. Currently, Tennessee law contains state-level provisions that allow a claimant to refuse a job in the first 13 weeks if it does not meet certain wage thresholds tied to prior earnings. But the problem is that our state only provides benefits up to 12 weeks. So that means the statute contains a timeline that is no longer matches reality. So we're just trying to clean that up and eliminate the confusion on that.
Thank you, ma'am. Any discussion on the bill? Representative Hale.
Question on the bill.
With questions been called, Madam Clerk, please open up the vote. All in favor of House Bill 2542 moving to commerce, vote aye. Those opposed, vote no. Madam Clerk, please take the vote.
Mr. Chairman, you have 5 ayes and 0 noes.
The ayes have it. House Bill 2542 will go on to commerce.
Thank you.
Thank you. Ready for House Bill 2108 by Leader Boyd. Leader Boyd, we're in a good standing here. Please tell us about House Bill 2108.
Thank you, Mr. Chairman. I actually do have an amendment on that.
Yes, sir.
And I'm showing drafting code 013475, Mr. Chairman.
That's what I'm showing. All in favor of the amendment, say aye. Aye. Representative Boyd.
Thank you,
please
Mr.
tell us
Chairman.
about your bill.
Committee members, I'm not sure if you're very familiar, but there is a industry that has developed over the last few years that's called third-party litigation financing. And so this bill will strengthen Tennessee's laws as it pertains to that. Now, this does not impact the practice that I'm sure you are familiar with, which is where an attorney will do a contingency case. This is actually a third-party lender that is financing the litigation. So what this would do, there's just 3 or 4 things that it does. It would prohibit foreign adversaries or sovereign wealth funds that are designated by the U.S. Secretary of Commerce, and that's a list of countries that we don't want doing really anything here. So it would prohibit those from doing it. It would require that litigation finance agreements be made transparent and available through discovery. It would prevent the financiers from directing litigation strategy or settlement decisions. It would require that the financier participate in the cost, not just the upside. But the final thing that it does, and I think it's important to make sure that this is central to the legislation, is that it would prevent the financier from benefiting more financially than the plaintiff, who's the real victim in this. And so, Mr. Chairman, that is what the bill does. I do have someone here today that's traveled some distance that, if it's okay, we could go out of session. That's Mr. Mark Barrett with the U.S. Chamber of Commerce.
Well, sure. We'll go out of session here and hear from Mr. Mark. Mr. Mark, if you would, just tell us who you are and what your title is. We're out of session. Right here, sir. Right here.
Thank you, Mr. Chairman, members of the committee. My name is Mark Behrens. I'm appearing here today on behalf of the U.S. Chamber of Commerce. We're in from out of town, and I'm proud to bring my daughter, who wants to go look at UT after this. So you Vols fans, so appreciate her shirt. Anyway, I'm here to talk about, in 2014, Tennessee passed a Consumer Protection Act dealing with an aspect of a financial product for legal services called consumer lawsuit lending. And this is sort of a follow-on to Tennessee's leadership in this area of regulating financial products related to litigation. What we're seeing in the last few years is big money investment bankers that are essentially treating our court system like casinos, that are loaning money sometimes in the hundreds of millions of dollars to private law firms to fund lawsuits. And then if the lawsuit is successful, the bankers get their take out of that. And it raises a lot of problems. As a lawyer, I went to Vandy for law school. And, one of the things we learn in law school is that lawyers have a fiduciary duty to their client. That means they have to put the client's interest first. But when you have a banker that may be controlling the aspect, it puts the lawyer in a bind about who's really controlling the litigation. Is it the client that decides on when the case should settle, or is it the banker? And what this bill would do is help make those lines very clear to say that the consumer controls her own lawsuit. The banker can't control their own lawsuit. The other thing that we're seeing is foreign adversaries. Believe it or not, we've seen some instances of Chinese funders that are funding patent litigation in the United States. And you might say, well, what's China's interest? Some of it may be that they can make a lot of money in this area. The other is, and our concern that's been raised by a number of U.S. attorneys general, is that as part of the discovery, the information that's exchanged in lawsuits, a Chinese funder may be able to get access to U.S. trade secrets this way. And so this is a national security issue. And this bill prohibits funding by foreign adversaries. So not by our allies, not by the UK or countries like this or Canada, but by foreign adversaries like China, Russia, North Korea. The bill stops those folks from getting access to U.S. trade secret information. And then finally, what the bill says to protect consumers, again, as the representative mentioned, is after there's a settlement on a lawsuit and the lawyer is paid, so the lawyer is going to get his or her full contingency fee. After that, the lawyer is paid, whatever is left, the consumer will get most of that. So the consumer will always be the biggest winner in his or her own lawsuit, not the bankers. And that's what the bill does. It's very straightforward. Similar legislation has now passed in 10 other states. Tennessee, as I said, was a pioneer in leading the nation in dealing with this other consumer product finance. And now we just ask Tennessee to take the next step and solve this problem as well.
Thank you, sir. Any discussion with our guest here? Sir, we appreciate your time, and yes, your daughter looks good in orange. We do have someone else that would like to speak, Mr. Brandon Bass. Yes, sir, if you would just come up, tell us who you are and who you're with.
Thank you, Mr. Chairman. My name is Brandon Bass. I'm the president of the Tennessee Trial Lawyers Association, and I practice out of Brentwood statewide. My concern and our organization's concern with this bill is not the consumer protection aspects of it. It is with what the bill describes as a discovery process involved in it. The vast majority of this type of financing for cases is done from a lender to a law firm's entire book of business. It's not a loan for a particular case. It is how the law firm covers their entire book of business, with the lender sort of spreading their risk across the firm's entire book of business. They might not get paid back on one, but they get paid back on another, right? With the discovery portion, what that means is in a Tennessee lawsuit, in every single case, the adversary would be able to ask the other side, the law firm, to turn over its own financial books for how it's covering the expenses in the case. They would be able to ask for the terms and conditions and the existence of those financing agreements. These are Tennessee law firms. These are Tennessee corporations and businesses that employ tens of thousands of Tennesseans that are now having to turn it over just for representing an injured Tennessean in a case. That is intrusive, and it has nothing to do with the merits of the case. There's nothing about that arrangement between a law firm and some kind of financer that means anything about who ran a red light in a wreck or how badly hurt the person was. It's also one-sided. It targets specifically the victim's law firm. If it was mutual and required a disclosure of who's bankrolling both sides, that might raise the same questions about why do we actually need this information? What does it have to do with the merits of the case? But as it is, it's going specifically to the victim's law firms and how they pay for the case. Thank you.
Thank you. Any discussion with our guest? Mr. Bass, appreciate you being here.
Thank you.
Yes, sir. Oh, sure, Pat. We'll go back into session here. Does anybody have any questions for our leader here? Speaker Marsh.
Thank you, Mr. Chairman. And Mr. Sponsor, I'd like to ask a question sort of related to the last speaker. Is that one part of the bill about discovery? Does that happen without the other parts happening, or without these lenders putting all this money in these cases? Does that happen if the lenders don't put a large amount of money, like a gamble? Does this discovery happen anyway? Or does one have to happen before the others happen?
Leader.
You know what I'm saying?
If, Mr. Chairman, the way I would describe it is, if this bill passes and there is a consumer litigation financing company that's involved in it, it is discoverable. That's what the bill would do. So that's not the case now. So we feel that's needed. We think that's important, and for all the reasons that we've outlined.
So if it's not consumer financing, what your bill deals with, is the discovery still required in a typical case, like the gentleman was just saying?
Mr. Chairman, now this may be deeper than my knowledge level, but there would be no financing to discover. So I don't. That's what they're hoping to discover through the discovery is that. So if it was a case that did not involve the third party litigation financing, then there would not be any. No one would be necessarily trying to discover that.
Okay, thank you.
Chairman Vaughn.
Thank you, Mr. Chairman and Mr. Former Chairman. It brings up a question. The gentleman was talking about basically the discovery portion of this would be intrusive to where they would go through and examine, I guess, their entire finances is what we were led to believe by that gentleman. Is the limits of the discovery of financing, can that be limited, or do we wind up in a situation where they have to say, hey, look, there is no litigation financing because here we are, our line of credit is from Pinnacle Bank and we're calling on it and basically having to reveal a lot of things that does not have anything to do with the merits of the case. And I can't believe that I'm agreeing with trial lawyers on this, but that seems to be a reasonable concern. I support the bill, but I'm wondering is there language in there that could be tightened up to where we limit what is subject to discovery? Because I wouldn't think that how much somebody owed on the credit line in the or what their payroll was for their firm would be necessarily germane to a case that's in front of them. And it could be that as good trial lawyers do, somebody's just throwing something up against the wall and see if it sticks with a committee member. But that's my question about this is, can the discovery be limited and still accomplish what it is you're trying to do here with this bill?
Sponsor.
I think that is something that is being discussed, a fix for that. So we can, that would not be the intent of the bill to do that. And so if the language needs to be tightened up, we can certainly amend that to clarify that what we're seeking is to determine if there is litigation financing. We don't need to probe deeper than that. So that would, I can commit to that and happy to make that correction.
I'm at the will of the committee. What do y'all, would you want to roll this a week or
Or do you want us to
move forward?
It's moving to a good committee, some guys there that I trust. So I'm happy if it's, I'm at the will of the committee, but I would love to see it advance to commerce so we could probably have the same folks come back and testify again. And by then we should have an amendment that would fix that.
All it needs a motion. Speaker Marsh.
Move it on out, and if there is any correction, we'll do it from the Chairman Vaughn's committee.
All right. Madam Clerk, will you please open up the vote? Yes. We're ready to vote on House Bill 2108. All those in favor, vote aye. Opposed, vote no. Moving it on to Commerce.
Mr. Chairman, you have 6 ayes and 0 noes.
Thank you, Madam Clerk. House Bill 2108 will be moving on to Commerce.
Thank you, Mr. Chairman of the committee. I'll see you in 2 weeks.
Yes, sir. Moving forward here, we're ready to hear House Bill 1447 by Chairman Baum.
Thank you, Chairman Darby. Here in Tennessee, we've got a very conservative state budget, but some of our Tennessee citizens don't necessarily have conservative budgets because they haven't saved enough money. They haven't saved money for medical expenses, retirement, education expenses. In fact, CNBC reports that if you look at people between the ages of 55 and 65, they've saved an average of $85,000 for retirement, and that's not enough. But in the private sector, only about 50% of all private sector workers have a retirement account like a 401k account. AARP has shown that if they had an account, they would be several times more likely to save for retirement than if they don't have an account provided by an employer. However, in the public sector, our treasurer has set up a fantastic retirement plan through TCRS, the Tennessee Consolidated Retirement System, where employees not only have a retirement savings vehicle, but the plan is fully funded. This is a conservative bill because it promotes saving money for the future. And the way it does that is it would require the treasurer and the Department of the Treasury to simply set up a similar parallel plan for private sector employees like we have for public sector employees, where the private sector employees would have the option to contribute money out of their paychecks into a retirement account that would be managed in the exact same way that we're already managing these accounts for public sector employees. These would be what we call defined contribution retirement accounts, not pension plans. And the reason why I say that is all employers would have to do is to provide the employee with a way to get money from their paycheck transferred into this fund. Employers would not be permitted to make contributions under this bill. The reason why is that would make them governed by ERISA. Employers also would not be covered by this bill if they already offer their employees a retirement account, like a 401k type account. This bill would only affect those private sector employees who don't currently have this kind of a retirement account already being provided by their employer. Contributions by the employees would be completely discretionary and voluntary, although the bill sets it up so that an automatic 5% of their paycheck would be contributed, but they could adjust this down to 0 if they want to. That would just sort of be the default. I think a bill like this would actually help private sector employers, would help them recruit workers because they could claim they offer retirement benefits, even though the benefits would actually be managed by the treasurer. There would be some administrative costs to this, as there are with any kind of retirement plans. Usually, the industry standard is for that administration fee to be about 0.25%, and it's paid out of retirement accounts. And in this case, the administration fees would be paid out of the private sector's employees' retirement accounts. The treasurer could partner with private sector firms to help manage these investments. So when you consider this, the cost would be a very, very low administrative cost to set up a plan that is similar to what we're already doing for tens of thousands of public sector employees. And the benefit would be lots of Tennesseans saving enough for retirement. A couple of years ago, some economists won a Nobel Prize for something called nudge theory. And what nudge theory says is it looks at consumer preferences and it says consumers are actually indifferent about a lot of decisions in life. There's very few decisions that consumers are really that passionate about. And if you just sort of nudge them in the direction of a wise decision, away from a foolish decision, they're happy to make the wise decision. But indifference and inertia keep consumers from doing the right thing. This would use nudge theory to basically set up private sector employees with a retirement account, 5% being contributed. And if nudge theory is right, employees would be happy to make these contributions, but they don't have the motivation to go out on their own and set it up on their own. But if it's set up for them, then it would be something they'd be happy to participate in. As good as this bill sounds, I am not convinced that the treasurer is quite as enchanted with it as I want him to be. And so I'm going to ask you all to take this off notice while I continue to work on making him more enchanted about these opportunities.
Chairman Baum, thank you for the great description there, and best of luck. Thank you.
Thank you all.
House Bill 1447 is officially taken off notice.
Thank you.
Moving on to number 4, House Bill 1705 by Chairman Rudd. Chairman, please tell us about your bill.
Thank you, and I'm not taking it off notice. This is a very important bill, and it's needed very much. It's a part of the illegal immigration package that we've been progressing. And what it does is basically this. We already have it now that state and local, including LEAs, when they hire, are supposed to use the E-Verify federal system, but they're not been doing it. So this puts teeth into that program, so that if they're not, the Attorney General is authorized to investigate credible complaints, and if they find that they're violated the system, the law that we're passing here, that they can withhold state funds, state shared funds. That includes grants, that includes direct payments, that includes any other funding that they have, including shared sales taxes as punishment until they cooperate. So that's what the bill basically does. It puts teeth into an existing program.
Thank you, Chairman. Any discussion on the bill? Madam Clerk, will you open up the vote? All in favor of House Bill 2108, moving on to commerce, vote aye. All opposed, vote no. Yes, is that not what I said? Oh, I'm sorry. I'm sorry, House Bill 1705. No, it's all right. It's all right. Madam Clerk, please give us the vote.
Mr. Chairman, you have 6 ayes and 0 noes.
House Bill 1705 will go on to commerce. Thank you.
Thank you, Chairman.
Yes.
Thank you, committee.
Hey, it's all right. It's all right. We're ready for House Bill 1958 by Representative Alexander.
Thank you, Chairman.
Yes, ma'am. Go ahead.
Thank you, committee. It's very rare that I get to present a bill that's the number is the same year I was born. And so don't calculate, just know I'm old. This bill, Mr. Chairman and members of the committee, Tennessee Code annotated 50-2-103A2 created a problem for businesses that pay employees on a commission or a base pay on a piecework monthly situation. The statute requires commissions earned in any given month to be paid by the 5th day of the succeeding month. For example, commissions earned by an employee in January would have to be paid by February the 5th. As many of you know, the process of calculating an employee's pay when based on commission can be cumbersome and may take more than 5 days to verify and calculate. This bill would allow employers to pay piecework or commission-based compensation on the last day of the succeeding month rather than day 5. This change would provide more flexibility and transparency to the process for employers and employees. Thank you, and I'm happy to answer any questions.
Thank you, ma'am. Representative Marsh.
Mr. Chairman, and this doesn't require that. It just says you can. You can still pay on the 5th day of the following month, but you don't have to anymore. Good
Sponsor.
deal.
Yes, that is correct.
Good
And what we found out is 9 out of 10 aren't paying on the 5th day anyway.
Any more discussion? We're ready to vote. Madam Clerk, please open up the vote. All those in favor of House Bill 1958, moving on to commerce, vote aye. All opposed, vote no. Madam Clerk,
Mr. Chairman, you have 6 ayes and 0 noes.
House Bill 1958 will go on to commerce.
Thank you. Thank you, Chairman. Thank you, committee.
We're now ready for House Bill 2453 by Representative Garrett. Representative, please give us a description of the bill.
Thank you, Mr. Chairman. House Bill 2453 was brought to me by the Attorney General in his office, and it's regarding trade practices underneath our Tennessee Consumer Protection Act. Kind of cleans up some language there. Under Section 1, we are streamlining some assurances of voluntary compliance with AVCs. Section 2 clarifies unfair deceptive acts, which are prohibited, simply deals with some radar detection devices and what we do as it relates to the radar detection devices for those that want to track or block folks from measuring your speed. Section 3, which is probably the most important piece of this piece of legislation, is that when the state is sued, what's happening in the discovery world, and that's how you find out information in litigation, is that if you're suing and it deals with the Department of Safety, which typically has nothing to do with the Department of Environment and Conservation, they're serving discovery on the entire state. So we're limiting the discovery to actually what matters in the case before that. So they're not blanketing the entire state agencies for a discovery. We're having a little bit of an issue with some lawsuits relating to discovery issues. So we're narrowing the scope of the discovery. Under Section 4, we're narrowing the publisher exception. There, under Section 5, we're also strengthening. We prohibited class actions last General Assembly. We're strengthening that portion here to make sure that we really mimic what's in the federal law. There's been some federal cases that still allow a class action. We got to make sure we prevent those that we did last session. So that's what Section 5 does. With that, all the rest of the legislation is really cleanup language. So I'll be happy to take any questions. I know there may be some that are here to testify. I'd welcome that as well if that's up to the committee. But Mr. Chairman, that's what the piece of legislation does.
Thank you, sponsor. We're going to go out of session here. Is there a Gerard Strunch?
Yes.
Please give us your name and your title there. And
My name is Gerard Stranch. I'm the managing partner of Stranch, Jennings & Garvey in Nashville, Tennessee. I have a class action practice that is nationwide. I have worked hand in hand with the state of Tennessee, and I'm currently representing the state of Tennessee in matters. And I wanted to talk only about one aspect of this bill, which is relating to the Section 5 modifications. And I'm not going to weigh in on the policy. I'm only going to weigh in on the practical effect of it. The litigation that this refers to is antitrust litigation, and that litigation is going on across the country, whether Tennessee allows it, whether there's class actions allowed in Tennessee or not. It's continuing. For example, one of the areas in which I have done this litigation across the country is against pharmaceutical companies for monopolistic practices and keeping cheaper generic competitors off the market. And one of those examples that we did it in was a anti-rejection drug for people that had had organ transplants. And this drug, if you bought the branded drug, was thousands of dollars a month for people to stay alive. And the generic competitors were available for hundreds of dollars a month. And we brought that lawsuit, and ultimately it was resolved. And there were hundreds, I think actually thousands of Tennesseans who filed claims and received real money back to them as a result of us having pursued that litigation. If this amendment is allowed, what will happen is that lawsuit will continue to go forward. It will be on behalf of citizens in other states, and the Tennesseans will not be recovering in that, because the Attorney General would have the ability to bring cases, but they can't bring every case that's being brought across the country. The legislature doesn't fund the Attorney General's office in a way in which they could afford to do that. So they have to be selective and determine which ones we want to get involved in or which ones we don't. And so when we look at a free and fair market, there are other people that are bringing those cases, and I believe that we should leave open the potential that Tennessee citizens can recover as a result of that. Because right now, what would have to happen if this passes is an individual Tennessee citizen would have to hire a lawyer to bring their individual claim. And I can tell you from that pharmaceutical litigation that we did, the cost of the expert to prove that they had monopolized the market was over $1 million. And so when someone's only out $500 or $600, that's the cost of the filing fee to file the lawsuit. So that would cut Tennesseans out of this because that litigation will go forward no matter what. It's just that Tennesseans, the individual Tennesseans, won't be able to recover for it. And so that's what I wanted to speak up on today. I wanted to be heard on, and I hope that you would consider that.
Thank you for your testimony. Any questions here for our guests? Thank you.
Thank you.
We'll go back into session here. Sponsor, do you want to ask or any discussion, or do you want to go ahead and bring up the eight? Okay, we'll go back out of session, and we've got another guest here from the AG's office. If you would, just tell us who you are and who you're with.
Good afternoon. My name is Kelly Measure. I am a Senior Assistant Attorney General and Managing Attorney in the Consumer Protection Division at the Tennessee Attorney General's Office. I wanted to, come up just to talk a little bit more about Section 5. We just heard from Mr. Stranch some of his thoughts about Section 5. And so I wanted to come here just to clarify a few things. So I think most importantly, this section of the bill is just reinforcing a class action prohibition that already exists under the Tennessee Trade Practices Act. So Tennessee Code Annotated 47-18 -106, I believe, already includes a class action prohibition. And so there's nothing that is being sort of added to this bill, in my view, that is not already there. The inclusion of this section is meant to reinforce the class action prohibition that already exists. Mr. Strange also mentioned, the generic drugs litigation that he's been a part of. The Attorney General's office has also engaged various generic drug manufacturers alleging, similar things. And so importantly, this does not leave Tennessee consumers without redress. There's also plenty of class actions brought across the country that Tennesseans opt into every day. And I know this because I am one of the folks in my division that reviews settlements that have to be submitted to our office under the Class Action Fairness Act, which is a federal law. So I review these settlements every day. And whether, a case is brought as a class action in Tennessee under another statute, or, whether it's a class action brought in another state, Tennesseans are opting into class action settlements every day. And nothing in this law would prevent Tennesseans from being able to opt into class action settlements that are out there and that exist and that they're able to opt into. In these types of cases specific to trade practices, which is what we're discussing here, class actions often benefit attorneys because the attorneys get paid to bring them, but often leave minimal recovery for consumers while creating high litigation costs. And so again, the Attorney General brings these cases under the Trade Practices Act on behalf of Tennesseans. And so I would submit that is protecting Tennesseans in this context.
Thank you, Ms. Kelly. Any questions for our guest? Thank you for being here.
Thank you.
Yes, ma'am. We'll go back into session here. Any discussion with our sponsor? Ready to vote? Madam Clerk, will you please open up the vote? All those in favor of House Bill 2453, moving on to commerce, vote aye. Those opposed, vote no. Madam Clerk, please take the vote.
Mr. Chairman, you have 5 ayes and 1 no.
House Bill 2453 will go on to commerce. Our next bill, House Bill 2454 by Representative Garrett. No amendments on this, right?
No amendment,
Okay.
that's right.
Sponsor, please tell us about your bill.
Thank you, Mr. Chairman. This is my 8th time to bring the Tennessee Bankers Association's trust legislation before this committee. And I wish I had my statistic because I don't remember my very first statistic in the first year of this, but in the past 9 years, we've gone from having $25 billion in trust management in the state of Tennessee to over $300 billion. And that's really because of the great work of this committee, the Bankers Association, their trust committee, because we have people's money here, but not necessarily the people, right? Because they live in various different states. And this is the reason we keep touching this piece of legislation to make sure we protect the trustees, we protect the beneficiaries, and we have easy and understandable pieces of legislation to make sure we're attractive to those companies that want to house their investments here that remain in trust. So this does several things. I won't try to get into it all because it's a little bit lengthy and tends to, when I talk about this stuff, people cross their eyes. So I'll try not to do that to you all today. But one important piece of this that was a little bit a surprise to me is that in the probate world, if you have a will that is done in a different state, technically we have very technical requirements to a will that's done here. Some states don't have the technical requirements that they do. They have their own, but they're different. And so theoretically, if they have a foreign will, that's a will from a different state, not a different country, but it's a will that's done in Wisconsin or Kentucky or Alabama. If they follow the rules of that particular state and it's a valid will, we will recognize that will here. We've had some issues in the probate process, and the trust and probate process can be very intertwined to make sure we do the regulations under the trust. That's one provision of this. We also clearly and clarify the efficiency of administrating the trust that deals with charitable purposes. Trusts sometimes are put together for tax purposes, and any distributions from those trusts must be made to a charity. So we're trying to make sure we clarify and make efficient the rules and regulations as it relates to providing for those trusts that gives to charities solely. Sections 3, 6, 7, and 15 are related to the trustees of a directed trust. Directed trust have a specific purpose. We're just strengthening that piece of that section in order when it deals with third parties and third parties trust advisors and protectors. I know that seems like what in the world am I talking about, but we have so many different provisions to make sure that when a trustee acts on behalf of a beneficiary, and most of the time those aren't the same people, we're doing the utmost ability to make sure that money gets for the specific purpose. We're clarifying that language in those sections. Also, if you are a beneficiary of a trust and that trust is at $100,000, that can be uneconomical for the fees that are related to administrating that trust. That's been $100,000 for a long time. We're simply increasing that to $250,000 for inflation purposes. So if a trust is $250,000 or less, the beneficiary can request to the trustee to go ahead and terminate the trust and pay out the principal of the trust if it's under $250,000. Right now it's $100,000. We think it's appropriate to raise that because it's set at $100,000 for a long time. Finally, there are many sections that are exactly like what I've described that are clarifying in nature. I'll be happy to address any of the provisions that you all have, but there's multiple. And so if you all have any questions, I'll be glad to entertain those to answer any specific questions you have regarding this piece of legislation. So
Thank you,
Chairman,
sponsor.
you're
Any
welcome.
discussion on the bill? Chairman Vaughn.
Thank you, Mr. Chairman. As surely as the Swallows will return home to Capistrano, Representative Garrett will be here with some language that at some point in time in his presentation, I just have to say, please make it stop. So
I tried my best, Mr. Chairman.
thank you. Thank you very much for this piece of legislation. And that was all I had to say it's like deja vu all over again.
Thank you, Chairman. Any more discussion? And I would like to say, as much as this committee likes the shower and the shot in the arm about what you said, hey, the real shot in the arm goes to Commissioner Gonzalez and his staff for what they've done with the trust here in Tennessee.
That's right.
Yes, sir.
That's right.
I think we're ready to vote. Madam Clerk, please open up the vote. All those in favor of House Bill 2453 moving on to Commerce, I'm sorry. House Bill 2454 moving on to Commerce, vote aye. All those opposed, vote no. Oh, no, that's me. Madam Clerk, please take the vote.
Mr. Chairman, you have 6 ayes and 0 noes.
House Bill 2454 will be moving on to Commerce. Thank you.
Mr. Chairman, committee.
Sir. Bringing up the rear here will be Speaker Morris here on House Bill 1800. Speaker, please tell us about your bill.
Thank you, Mr. Chairman. And this bill also is brought by the Tennessee Bankers Association and to address digital assets. It's a small little bill, 75 pages long. This bill is about modernizing Tennessee's commercial laws to keep up with today's technology. This would enact UCC Article 12, which would give our courts, businesses, and banks clear rules on how digital assets can be owned, transferred, and used as collateral. More than 30 states have already adopted these updates, and Tennessee is falling behind. UCC Article 12 is needed to provide clear legal rules for owning, transferring, and using digital assets, things that exist only electronically. Article 12 does not regulate cryptocurrency or create digital currency. It simply modernizes property and commercial law so that it works the same way for digital assets as it already does for paper and physical assets. This bill also amends and updates several existing commercial laws to ensure they all work together and are consistent with UCC Article 12, which accounts for the length of the bill before you. This bill modernizes Tennessee's commercial code. It gives clarity, protects consumers and businesses, and keeps our state technologically competitive and aligned with national standards. I've respectfully ask that you vote to support this bill, and I stand for questions.
Thank you, Speaker. Any discussion on the bill? Chairman Vaughn.
Mr. Chairman, I'd like to ask that we call the question on this bill.
Hallelujah. Hallelujah.
Madam Clerk, please open up the vote. All those in favor of House Bill 1800 moving on to Commerce, vote aye. All opposed, vote no. Madam Clerk.
Mr. Chairman, you have 6 ayes and 0 noes.
House Bill 1800 will go on to Commerce. Well, that wraps us up again. Thank you all again for being here, and just need that's what I was looking for. Adjourn.